you, and we will start our panel focus on the ICC and the challenges and the impact of ICC work and how this practice will create new international criminal or not. And it's my great pleasure to introduce our distinguished speakers today. And now we have Kateryna Rashevska. She is expert at the Regional Center for Human Rights, PhD in International Law. Also, today we have Hanna Kuczynska. She is professor in the Institute of Law Studies of the Polish Academy of Science in Warsaw, president of the Polish group of the International Association of Criminal Law. And today our panel is mixed panel, and we have online speakers. And today with us Dov Jacobs, he is defense counsel at the International Criminal Court and the Mechanism of International Criminal Tribunals, associate member of the law firm 9 Bedford Row in London, visiting professor at Leiden and Lille in universities, founding member and former vice president of the ICC Bar Association. And also today with us Nadia Volkova. She is head of the Ukrainian Legal Advisory Group. And now during this discussion, we will talk about the internal and external processes affecting the work of the International Criminal Court, its effectiveness and the challenges it faces. The International Criminal Court has faced criticism for the cases it has selected, the number of cases it has considered, and the politicization of its activities. And despite all the turbulence surrounding the ICC, it remains a beacon of hope for victims of international crimes around the world, offering the prospect of justice, justice for everyone, justice for international community, justice for Ukraine and for another state. Also, being in Ukraine, we recall the thorny path Ukraine undertook to ratify the Rome Statute, which was finally achieved last year. And now that is why my decision to start this discussion with impact the situation in Ukraine on the activity and capacity of the International Criminal Court. Today, during this conference, has already discussed the process for peacefully setting the international conflict in Ukraine and how this process affect the ICC in this context, and how can the inevitability of punishment for international crimes be ensured in the ICC in the event of peace negotiation in Ukraine, in other places in the world. And I invite for first round of this discussion, I will start with Kateryna, then we discuss.
So the brief intervention, yes, introductory remarks. Okay, so as Nataliya has said, my name is Kateryna Rashevska, and I'm a legal expert at the Ukrainian non-governmental organization Regional Center for Human Rights. Our organization was established in 2013 in Sebastopol, and that is why since the beginning of the occupation of the Crimean Peninsula, we are cooperating very closely with the ICC. As for today, we have submitted already 18 communications to the International Criminal Court. I am a co-author of 4 of them, and these communications are related to the crimes committed against Ukrainian children, namely unlawful deportation, forcible transfer, unreasonable delay in repatriation, unlawful confinement according to the Rome Statute. Also, all the re-education efforts of Russian and Belarusian agents under the umbrella of discriminatory persecution as a crime against humanity, and unlawful passportization as a illegal basis for Russians in order to facilitate adoption of Ukrainian children, and also their illegal inclusion into Russian cultural, religious, social space. Our work with the ICC is like partially public, but also we have several dimensions I cannot discover. But what is really important is that I'm quite optimistic. We started our discussion with some members of the audience in lobby, and some of them told that it will be the discussion about the death of the ICC. I don't think so. The ICC will not die, and I hope that during this discussion we will highlight why, what are the reasons, what the ICC can do for Ukrainian victims and survivors of all these atrocities committed by Russians, and also how we can use the ICC as a mechanism of justice more efficiently.
Thank you. And then I would like to invite for introduction remarks Nadia Volkova, and please, floor is yours.
Good afternoon, I suppose, in Ukraine to all the participants. I'm grateful to be a part of the panel. Thank you to the organizers for inviting me. I'll be brief. We founded ULAG on the 17th of July 2018. So today is our birthday on this International Justice Day, which we're also actually very proud of. It was a coincidence, it wasn't planned, but here we go. We've been working on the implications and consequences of the armed conflict, primarily in eastern Ukraine prior to full-scale invasion. And we started cooperating with the preliminary examination team in 2015, essentially when after Ukraine submitted its declarations of accepting the ICC jurisdiction. And ever since then, same as the regional center, we've been in close communication and information exchange with the principal actors of the ICC working on the case, on the situation in Ukraine. Also, I collaborate and engage with the ICC as part of the co-chair of Workstream 4 of the Dialogue Group, which was established in 2022 by the EU Commission, the ICC, and Ukraine. It is being chaired by the Ministry of Foreign Affairs of the Netherlands, and the sort of main actors of the 4 work streams are the Office of the Prosecutor General, the International Criminal Court, Eurojust, and civil society. And in that sense, we also have a regular information exchange, also speaking about needs and current relevant processes that are taking place in relation to ensuring accountability, in particular, how the ICC is playing a role in these processes. Thank you.
Thank you, Nadia. Congratulations with your date for today, and how it's important, this type of work for Ukraine, for justice and for accountability. Thank you. And now I would like to invite for introduction remarks to Hannah. Hannah, the floor is yours.
Thank you very much, and thank you for the invitation to the organizers and for your hospitality here in Kiev. So as for introductory remarks, it started with to pick up where you left these remarks. There is a heavy criticism towards the ICC that we are facing right now in the media and also among specialists. And this criticism is pointing to the lack of full cooperation of state parties and at influence of politics on the functioning of the ICC. So people are criticizing the refusal to cooperate fully by the states. So the states refuse to cooperate with the ICC, or they try to avoid the jurisdiction of the ICC. So the states don't want to participate in this goal of the ICC, that is ending the impunity of perpetrators of crime. And this field is becoming a field for political negotiations and abuses, as we discussed in the last panel. Potential peace negotiations may use justice and impunity for perpetrators as a bargaining chip, which shouldn't take place, but is taking place. So that's another point of criticism. But the ICC statute is very clear, and the institution of the ICC should be clear to us. The ICC is an achievement of the whole international community. So this is something the international community has created for the community and for people, for victims, and its existence and its functioning is a great success. So if we are speaking about a failure of the ICC, we should be rather speaking about, or death of the ICC, we should be rather speaking about the failure of states parties who refuse to cooperate, who refuse to join this order, who refuse to perceive this goal of ending impunity. So the states first created this institution, created the international order, and then created the ICC as the guardian, not of the galaxy, but the guardian of this order, as the watchdog. So the ICC should help us, people, individuals, to guard the international order. And if it's not fully successful, it is only the failure of the parties who first created it, and now they are weakening its position by refusing to participate fully in this order. And we have to remember that the ICC was also created by Russia and the United States, who these states signed the treaty, the Rome Statute, but then refused to ratify it. So when we speak about the ICC, we should start the discussion not from the failures or from the possible death, but from the real role of the ICC, and we are responsible for stressing this role. So we have to always repeat to everybody who wants to listen that the ICC builds precedents and shapes legal awareness at the global level. It is an institution established in order to protect universal values and achieve global goals, and it has been established in the name of humanity and mankind, not for its sole success or for its own purposes, but for the whole mankind. And all the state parties are obliged to cooperate, and they agreed for this obligation by ratifying the treaty, although they are using different strategies to avoid it. So that's for introductory remarks.
Thank you, Hanna. And now I would like to invite Do for your introductory, please.
Thank you. I share my panelists' appreciation for having been invited to this conference and to join you once again after having participated last year. It's always a privilege and an honor to be with you. I hope next year I can be with you in person. Happy birthday, Nadia. You share a birthday with Day of International Justice. Sadly, I share a birthday with the 11th of July, which is a commemoration of the Srebrenica massacre. So I would have preferred to share a birthday with the Day of International Justice. As a general introduction, again, I'll try and be brief as well. To echo what the previous speaker said, the ICC is facing challenges. Everybody in the room is probably extremely aware of the pressure from powerful states, which, independently of the general tension of an international court operating in a complex political environment, which it has been doing since 1998, there is no denying that the pressure is even stronger today, with especially with the sanctions by the US against judges and prosecutor, which makes so life at the ICC, and I'm there every day, difficult. Just in terms of atmosphere, in terms of capacity to work. It's creating obstacles for the work of the court. But again, I insist, there was never this idea that the ICC would not have to operate within those parameters. It was always going to be a court which would be facing political challenges, which when it comes to national interests of states, I'm not saying I agree or I'm happy about the situation, but that's the reality of the international legal order, the international relations, that when the interests of powerful states are at stake, there will be tension with what we might imagine is a pure exercise of international justice. And this is what we do every day at the court. We try to operate between those parameters without ignoring them. And as defense counsel, we are faced with similar challenges in terms of cooperation, in terms of accessing the crimes. It's the same when I represent victims to get this message across that there are limits to what the ICC can do. And even though it's a beacon of hope, we have to strive every day to have the humility to try to make it better rather than think it's already there. I love the comparison to the Guardians of the Galaxy. And if we push the comparison further, maybe the ICC is like Groot, for those who know. Groot always is reborn. If you cut off his arm, he's cut off his legs, there's always a baby Groot coming up. And maybe this is a positive image, paradoxically, of the ICC, that despite all the pressure, I am Groot. I am international justice will always be a guiding principle. And I think I'll stop here. I can make other comments in the context of the specific discussions. Thank you.
Thank you. And now return to the political and international law dimension of the ICC activities. The past 2 years have once again highlighted systematic gaps in international criminal justice system. Firstly, there has been a failure by state parties to comply with ICC arrest warrants, and there has been a lack of accountability for non-compliance with obligation under the Roma Statute and international treaty law. Secondly, there is Hungary's process withdrawal from the Roma Statute. Might this trigger a systematic withdrawal of states from the ICC, as is currently happening with the Ottawa Convention? Thirdly, there is the issue of sanctions imposed by states against ICC judges. Might this affect the court's independence? And furthermore, we cannot ignore the failed vote on the second Kampala amendments on the one hand, and on the another hand, the process of the desire to expand the jurisdiction of ICC to include new crimes such as ecocide, as we today discussed. And also, in this light of these circumstances, I have a difficult questions for you, for panelists, honored panelists. How will the current political processes affect the work of and effectiveness of the ICC? What will the future of ICC? How should or how can ICC change the approach to be the strong institution for justice, for international criminal justice? Please, Kateryna, we will start.
And how many time do we have to address this huge question? Because, actually it is for the whole day, maybe for 1 year of lectures for students. But I will try to be as laconic as possible. And as an echo to what you have said about all this non-execution of the arrest warrants, also sanctions against Karim Khan and some of judges. However, here I would like to highlight that officially, publicly on the website where the order of Trump is published, only Karim Khan is included into Annex A as a person under the sanctions. So I will start with the fact that not only Mongolia, but other states non-executed arrest warrant decision of the ICC. And lastly, it was Nataliya. So the state, which is appearing to be very justice-oriented in the case of the investigation and prosecution of the crimes committed by Russians in Ukraine, non-executed arrest warrant against Libyan General al-Masri, who committed actually war crimes and crimes against humanity, including crimes against children. It cannot have some impact on the investigation of the situation in Ukraine because, of course, the so-called countries of Global South will tell that why we should execute the decisions if even countries of the European Union with all the standards of justice, the rule of law, are not doing the same. And we should take it into our minds that everything which has happened in other situations cannot have some impact on the investigation of the situation in Ukraine. This is my first point. The second point is that when we are talking about sanctions and some other dimensions of the foreign policy of the United States, as for the investigation in Ukraine or investigations against the so-called alien states, so we should talk not only about visa restrictions and some freeze of accounts of Karim Khan in the United States, if he has such account, but we should think about other aspects like cutting of funds, for example, for Ukrainian non-governmental organizations who are involved very hugely in the process of documenting war crimes, crimes against humanity, some elements of the crime of genocide, and also who are assisting the same work of our Office of the Prosecutor General, security services, and so on and so forth. With this significant cutting, it is now very difficult, but it will be more difficult in future. It is also about some suspension of funds for the operational work of the ACA group in the OPG. It will have an impact also on the investigation of the situation in the ICC. It will also about the suspension of financement for the Yale Humanitarian Laboratory, who was directly involved in the process of documenting crimes against Ukrainian children, but not exclusively. And it is also about some possible end of cooperation between the ICC, non-governmental organizations, Ukrainian governmental organizations, and American companies who provide us with special software in order to collect, to maintain, to transfer all evidence by proper manner. It will have some impact, not only some public sanctions voiced many times as for visa restrictions. This was the second point. And the third point will be related to all these peace talks and negotiations, because I'm really preoccupied with it, not only because of the possible use of Article 16 of the Rome Statute in the context of suspension of investigation, for example, as for Putin and his crimes, because I am sure that Putin is very sad that he was able only to visit Mongolia and not, for example, to go to Indonesia, to Brazil, to South Africa, where they had many meetings of BRICS, of G20. So not only because of Article 16, but because of the fact that sometimes many public figures, like Secretary General of the United Nations, are trying to hide under this umbrella of restoring peace for Ukraine, some efforts to just make some rapprochement to the Russian Federation and to try to somehow normalize its activities, or just to help the Russian Federation to share its propaganda narratives. It was with the visit of Secretary General of the United Nations to Kazan in October 2024. Actually, it was the day before the pretrial chamber decision on the non-fulfillment of the obligation of Mongolia as for the visit of Putin in August the same year. And we know that the Secretary General is like the guardian. I also like this comparison of the Rome Statute, and it was really strange. When I was in the United Nations headquarters in New York in November the same year, in 2024, of course, we asked the representatives of the Office of the Secretary General what has happened, and they told, "Oh, you should be grateful for this visit. frankly speaking, I felt myself like maybe very similar to our president in the Oval Room, that we should be grateful. Secretary General visited President Putin with arrest warrant, with all these shaking hands. So he was trying to restore peace. And according to these people from his office, it helped. Maybe only me. I don't see the effectiveness of this trip, but of course it is also about undermining the efforts of the ICC and also about some possible lack of credibility because of all these visits, because of all these statements, and because of all this non-execution. So just in order to not stop on this allegedly set point, I would like to tell that as for today, many processes inside the ICC is happening not publicly. So something what has already been done is not for the whole audience, but there are many rumors, and according to these rumors, there are some developments, even if we don't see them now. So let's stay optimistic. I am sure that the investigation of the situation in Ukraine will not stop. I hope that the United States will not use this possibility to suspend the investigation as for Putin, according to Article 16. And why I am talking about the United States, because as we know, France and the United Kingdom since 1989, they are not voting no, so they are not using veto in the Security Council, and if they are voting yes, so it means that there will be suspension of the investigation. So all cards the United States have, but I am sure that everything will be okay, and according to their current position, they would like the investigation of the situation in Ukraine happening in the near future. I will stop here because it seems that I abuse my time.
Thank you so much for this very complex analysis for advantage and disadvantage in activity of ICC, but not only focus on in ICC, but focus on UN and the activity of Secretary General. And also when we talk about, it's not only about state obligation, it's also about obligation of international organization, international government organization to cooperate with ICC, because it's this system is complex system. This works, that all elements of this system work. That's why it's really important to respect international law, international criminal law, international treaty law, and other treaties in international law, because it's complex. And now I would like to invite for our discussion Nadia Volkova about her view of these circumstances, of this future of ICC in these circumstances. Please, Nadia, the floor is yours.
Thank you, Nataliya, and thank you, Kateryna, for your remarks and for setting out the background sort of for this discussion. I would like to probably shift it a little bit and situate us in a more sort of global context of things, and probably speak to what our role as a civil society should be in supporting and maintaining the operations of the ICC, because I do believe that civil society plays one of the most critical roles in the survival and in the prosperity of this institution. And I speak about prosperity because I, like Kateryna, remain optimistic that, you know, the humanity will prevail. And to me, the ICC is the manifestation of the human, or part of the humanity of human nature of our society. I think what the ICC has constantly struggled with since its inception is actually it's been battling for its survival. We have to remember that this institution is not that old. It's only 25 years old. For a global institution like this, I think it's not an old age. It's not a long time at all to actually find its feet, 2 feet to stand firmly on the ground. And if we have another analogy, sorry, this panel has been about analogies. To me, it's like, you know, a sort of a young thing, a child probably, that, you know, if you want it to grow up really strong and powerful, you actually nurture it. And what we're seeing right now, especially lately, the nurture element has been undermined by the mostly political interferences and lack of support. We've always been saying that political element should not be part of justice. You know, justice processes, politics should not interfere with them, because justice needs to be impartial. But I guess when justice threatens and is perceived as a threat, that's when this statement about politics not being part of justice doesn't really stand as such. And I think the quicker we recognize it, that we actually have to deal with the political side of justice as well, the better it is going to be for us and for finding the best solutions of support. And we've been seeing it more and more lately with the ICC sanctions, with the situation with the states, with Israel, also Ukraine to some degree, because, I mean, mostly on the side of Russia, when even though it hasn't been so much as political pressure from the Russian Federation, it has been more of a security attacks, and also, you know, and I'm referring here to a massive cyber attack that happened in 2024, but also sort of discrediting it on a very nuanced level, and using the propaganda, public manipulation, spies, if you like, as well, to undermine the institution from within. And I think we also need to recognize that there are limits to where one can actually withstand or find countermeasures to the political pressures of certain states. And I think each of us, as a supporter of the ICC, has our role to play. And the parameters of that role, or the scope of that role, is also can be very different. But I think it doesn't mean that we shouldn't be doing that or feel discouraged, because, for example, as the latest situation with the Kampala Plus consideration shows, Nataliya referred to that process and the outcome, that which hasn't been so positive, but at the same time it hasn't been that negative. And I think there is still scope and room for pushing this process, for maintaining this process, because if Ukraine, for example, should play an important role in moving this process forward, because obviously, I mean, just for the sake of our audience and sort of updating them, those who don't know what was the outcome of the Kampala Plus session, is that the amendments haven't been voted. They haven't found the support, mostly because there was again, political resistance from certain states. And, you know, the usual suspects, it was Great Britain, France, New Zealand, Japan. I think they showed the most sort of objection to amending the Kampala provisions, whereas at the same time, they have also avidly supported the establishment of the Special Tribunal on the Crime of Aggression. And here we've been talking and considering the double standards that the states have been demonstrating. And the question is, okay, what can we do with that? How can we influence, or what kind of tools we can advocacy tools most likely use in order to fight these double standards. I think there are ways. Every one of us can be very creative in sort of devising these tools and developing them, and then in using them as well. But it's very important that we actually don't stop. And there are various international fora where we can show that support, where we can sort of stand up for the ICC and object to double standards, especially states using them so blatantly, so to speak. And I think the role of Ukraine should be actually also not siding or supporting this manifestation of behavior, but rather actually standing up and leading by example and showing that we're an interesting party. We are not just thinking about ourselves, we're thinking about other states who have suffered or will suffer from the crime of aggression. And the more universal instrument we have, the better it's going to be for the greater humankind. And I think if we actually adhere to this line of behavior, then the chances are that we will absolutely lead by example, and other states may also follow. And as civil society, I think it is our role not to be silent, for sure, not to be scared into silence, find ways to be, on the one hand, diplomatic, but on the other hand, also delivering the messages that we think should be delivered, and use various fora to that aim, I guess. I'll stop here. Thanks.
Thank you so much, Nadia. Yes, it's really important to show the role of Ukraine, crucial role of Ukraine as civil society, Ukrainian civil society organization for documenting international crimes, for this advocacy company of ratification Rome Statute of the accountability for aggression, crime of aggression, and to show why it's important for Ukraine and for world, why it's important for victims, and also maybe the role of Ukraine in and this aggression, Russian Federation, show us how it's important to use all mechanisms and bring back understanding the role of the accountability and accountability for crime of aggression, and the role of special tribunal as the role of Kampala Plus 2. Thank you. And now I will give the floor to Hannah to your remarks about these challenges and this way how to resolve these challenges for ICC.
Thank you. Well, unfortunately, I don't have a universal prescription for that, except for saying to the state parties, please comply with this, with the arrest warrants and with the obligations. So I have also chosen 3 areas for the discussion that you provided us with before. So in the beginning, the execution of arrest warrants that draws so much attention, so much public attention, which is strange because so many arrest warrants have been executed and they didn't draw so much attention. Maybe because they were not against such well-known persons, public persons. But yes, the last 2 arrest warrants are issued against the head of the state, like the president and prime minister, drew so much attention because there were different techniques and excuses used by the states not to execute these arrest warrants. And the most popular among these excuses was to invoke immunities. And it created some type of doubts that maybe these excuses are real reasons, but it should be put straightforward from the beginning that immunities are not a real reason to refuse obligations resulting from the Rome Statute. They are just excuses, because the Rome Statute is very clear. Immunities of the leaders of state do not apply before the ICC. But states invoked Article 86 of the statute, like France or Italy, saying that, well, but we have obligations towards other states who are not parties to the Rome Statute, so we have to choose these obligations first. But a drawing is very helpful because immunities between states are horizontal, and immunities between states and the ICC are vertical. Yes, I hope I didn't mix it up. So it was quite clear from the beginning that vertical obligations are more important. It's also clear in the international law and international criminal law, and this assumption was confirmed by the ICC, which reacted to the non-compliance by Mongolia with the arrest warrant against Putin. And in a statement, the ICC confirmed that vertical obligations, vertical immunities should always prevail. Because that's why the ICC was created. That's why the states created the ICC, not to find excuses later, not to cooperate and not to fulfill obligations. So yes, we also experienced not only refusals to execute arrest warrants, but as in the case of Poland, promises of keeping safe the Prime Minister Netanyahu. And my friend, Professor Patrycja Grzebik, tried to save the Polish government by saying, well, protection is not refusal. Protection could mean that we could transport Netanyahu to The Hague safely, assuring his protection. But, well, it was not a joke, unfortunately. But we should also always stress two cases when the arrest warrants were or will be executed, like in the case of President Duterte, who is in the ICC right now, in the prison of the ICC right now. There was also not much hope that these arrest warrants would be executed, but it has been. Of course, there is a discussion: is it a victory of the rule of law, or maybe a result of brute friend-enemy calculations? Because the two ruling families in the Philippines, Marcoses and Dutertes, used the ICC to fight against each other. But anyway, let's focus on execution of the arrest warrant. Also, the president of Sudan, al-Bashir, was searched for many, many years, and for many, many years it has been considered to be the prime failure of the ICC, that he was traveling all across Africa. And what happened now? The change of regime. Al-Bashir is in prison with a promise to surrender him to the ICC. Recently, I've checked the state of the affairs in this situation. Well, unfortunately, he is not quite healthy. His illness can be an obstacle to the surrender, but this is still almost a success story. So somebody who was impossible to apprehend has been apprehended and will be perhaps surrendered to the ICC. And the third issue is the sanctions. And I strongly protest against the use of word sanctions, because in the understanding of international law, these are not sanctions. They are illegal, actually. This is revenge. And if we see the reaction of the states towards the arrest warrant issued against Prime Minister Netanyahu, we should compare it to the reaction of Russia when the arrest warrant was issued against Putin. What Russia did, they opened a criminal case against the prosecutor and judges of the ICC. And Professor Hofmański, who was the president of the ICC, my friend also from Poland, well, sacrificed his whole family and private life for issuing this arrest warrant. So his whole family and his life will never be the same. So it was an act of great courage, in my opinion, because, well, you know, the consequences. Well, Russia also threatened to target the court in The Hague with missile strikes and issued nuclear threats if any country arrests Putin. Its capital would be destroyed in 8 minutes. I don't know why 8 exactly, but these are the threats. And the revenge of the United States is more subtle, but it's also a revenge against Prosecutor Khan. Because it's not only visa restrictions, it is prohibition for anyone, including US citizens, from providing funds, goods, or services to designated persons with high potential penalties for the violation. So that's also a very important part of the revenge, financial revenge. And the last issue, very briefly, is peace negotiations, amnesties, and possible dismissing a case by the ICC. But we have to think about the ICC as not the sole guardian. There was a group of guardians. They supported each other. I'm sorry that this not very ambitious movie became a comparison and a metaphor for this panel, but states, the ICC, other regional courts, they work together. And we can't think about the ICC as the sole protector of this global order, because states have priority in jurisdiction. And right now, the most important form of cooperation with states for the ICC is positive complementarity. So there is a lot of negotiations, lots of discussions between the states and the ICC, potentially other courts, about what forum is the best to prosecute certain persons. So I can imagine that there is a lot of discussion about who should be tried before what court. And the ICC encourages states to adjudicate cases because the states should do it. The ICC is only for the most important leaders and most serious cases because of the capacity and financial capacity also. So this is the whole organism of protection of international criminal law and global order. And even if the ICC drops some part of the case, the states or regional tribunal can pick it up, as we can see in the case of aggression, the crime of aggression. So we should therefore stress also the obligations of states towards prosecution and protection of the order.
Thank you so much, Hannah, for your remarks and conclusions. And it's really important to understand that, yes, first of all, we should talk about the state obligation to investigate and prosecute international crimes, crimes against humanity, war crimes. And also, we know that all states are the party of Geneva Convention. That's why all states have this obligation to investigate and prosecute war crimes. And first of all, it's moral obligation and legal obligation to do this, and also ICC to help these states to do this hard work, to use this principle of complementarity, and also this helps to show how to use this, possible qualification of these crimes, how the way for national legal system, for national enforcement agency to work with these cases, and to do this work good, in have this best national practice. And maybe because the idea is for victims, it's for justice for all level, but first level is national level, then international for common values as a justice. And now I would like to invite Do for our discussion, for your remarks.
Thank you. Yes, I think we might have been overly ambitious with 3 rounds of questions for this panel, given the number of topics that were addressed. So there were quite a number of issues that were discussed. I want to just follow up on the point I made. I see myself twice talking to myself on the screen, but it's a bit confusing for me. So I'll try to concentrate. Nadia mentioned the political, dimension, and I think we do a disservice to the ICC. I've been working in this field for 20 years by not taking into account the reality in which it operates. We might not like it, we might regret it, we might want a better world. We might want a world absent of politics, absent of, with full state cooperation, but that's not the world we have. And so even as we daily, all of us strive to make the ICC more effective, we can't just ignore reality. And that's a starting point in analyzing. And the fact that the ICC is a political institution on very many levels is a reality. It's a reality that it's faced with political challenges when it deals with non-state parties, but even in its daily life, when the ICC prosecutes a head of state, it has a political impact. It might not be a political decision, it has a political impact. When the ICC prosecutes one side to a conflict, I was on the Gbagbo case, the fact that the ICC prosecuted, Laurent Gbagbo, but not Ouattara, had a political impact on the, local politics in terms of selectivity, etc. So we can't be naive and think that there's no, political impact of the ICC in the places it operates and in terms of what it's trying to achieve. So I think that's one general point I wanted to make based on the discussions that were initiated by my co-panelists. And in this context, the question is, and Nadia, sorry, I'm picking up on your points, Nadia, because I found them very interesting. I often hear the idea that the ICC is a young institution, but we don't think, and I kind of agree, even though 27 years is not, that young anymore. And it was building on the experience of the ICTY, and it made mistakes that it shouldn't have made from day one, having the experience of the ad hoc tribunals, in my view. But accepting the young aspect, we don't ask our kids to do certain things when they're young. And again, I share the frustration that even though the ICC was created with a universal ambition, it is not a universal court. It's just that's a reality. Again, it's not something I'm applauding or agreeing with. And I just put it bluntly, when you look at what the ICC is doing right now, for me, there's something disturbing or problematic in the fact that the ICC currently is dealing with so many non-state parties. For itself, in terms of its own ambition and its own capacity to be effective. It was never designed to deal exclusively with non-state parties, and that's what it's becoming. Russia, Palestine, Georgia, US with the Taliban and Afghanistan, Sudan, Darfur, Libya, that's Philippines, that's a lot of non-state parties. I don't think anyone, when the ICC was created in 1998, would have said, oh, most of our work will be non-state parties. No, we're going to deal with state parties who cooperate, who allow us to come to investigate. This is a starting point. This is how the ICC was conceived as a treaty, was based on cooperation. So again, I'm not saying this is a good thing or a bad thing. I'm saying that the difficulties the ICC is faced today is because it's dealing so directly and so quasi-exclusively with non-state parties. And this leads to political pressure. This leads to pushback by the non-state party in question. And again, maybe we can denounce that, but it's not surprising. We shouldn't be surprised, or in French, you say that you're falling off your chair, tomber de sa chaise. We're not falling off our chair. We're all very aware that this was a natural thing that was going to occur. There was nothing surprising about this, and we have to take that into account in how we're approaching. I won't comment on the Duterte case because, for transparency, I'm his associate counsel on the defense team. So there is a challenge to jurisdiction currently pending before the ICC. So we'll see how that pans out. I wanted to say a word on immunities, but I think that's an interesting example of, accepting, despite our ambitions, that there's a gap between where we are and where we would like to be. And that, ambition doesn't mean we can skip legal steps. And I respectfully disagree with my co-panelists that it's so obvious that immunities don't apply for heads of state of non-state parties. There's been a lot of criticism of the case law of the ICC from not just, evil dictators who want to escape impunity, by respectable professors and academics and specialists of public international law. And personally, in my own capacity, I've disagreed with the ICC case law, and I think we can have a reasonable disagreement on this. And I don't think it's that clear that the ICC can magically make immunities disappear just on the claim that it's protecting humanity as a whole. I would love that to be true, but the rules of public international law don't function like that. And I think that we can't just dismiss a legal debate on this, but I won't go into more detail. We can discuss it later if you want. And trying to keep it short, because I know we have a lot of issues to discuss. So the question, this complexity and political complexity also flows through to the question of amnesties, which was mentioned. Again, amnesties offend our sense of justice and fight against impunity. There is no doubt about that. But also, amnesties have been a tool of peace building and peacemaking for centuries. It doesn't mean we have to continue using it, but it has been an aspect of that. And we can approach this from two angles. The first one is a technical angle at the ICC. And I don't know if you want me to go into technical details on this, but the short answer is that probably amnesties will not be accepted by the ICC. That's a simple point. Whichever ways they're framed, as ICC is built in its purpose, in its object and purpose around criminal investigations, criminal prosecutions. I've worked on this in the past. You have the Libya example. So, I can't give a definitive answer on this, but I think on balance, it's very, very unlikely that the ICC will recognize an amnesty as being an obstacle to the prosecution, as justifying not prosecuting. However, this doesn't mean amnesties can't be used, because the ICC is not a court of legality of amnesties. The only thing the ICC can do is say, okay, I have this one individual I want to prosecute. Does he have an amnesty or not? And this person, this individual I'm prosecuting, cannot claim an amnesty. It doesn't mean that the amnesty cannot be used as a political tool domestically at all. But it means that this specific individual will not be able to raise as a admissibility point, or as in order to not be prosecuted, the amnesty. And having this more nuanced approach allows for some room for amnesties to be used domestically. But that's another debate, of course. That's why I'm distinguishing the technical discussion from the political one. But I think that we should not give too much importance to the ICC as an obstacle to use of amnesties. And again, from what I hear in the panel and my discussions over the years, the tendency is that amnesty should not be used, and that's fair enough in the peace negotiation. I'm trying to see if I should stop talking. I could go on forever on immunities and non-state parties, but the bottom line is that, again, the ICC is an institution that is trying to operate in a complex environment, and daily, as I said, for the prosecutor, defense, victims, we're all in the same boat, really. Usually people tend to oppose all of us, which I think is not very productive, because a working justice system requires also a defense counsel that can work correctly, respecting due process, etc. And that we cannot ignore that reality. And just one point on cooperation. Maybe I'm going to sound too realistic or too real politics compared to the ambitions of ICC, but I have difficulty completely not understanding the position of a state like Mongolia, for example, given its geopolitical situation, being requested to arrest Putin, which is a powerful state, as a neighbor. And maybe when you're working at the ICC as a judge, this is what you should require, this cooperation, based on this case law from the ICC, which I think is wrong, but it is the existing law right now, so Mongolia had to respect it. Or Italy with Libya, and the political pressure that Libya is putting on Italy in terms of immigration flows and etc. It might be a problem that they don't cooperate, but again, it's not surprising that Mongolia does not want to offend its powerful neighbor. And it might be sad, but this would not change just by calling for cooperation. And we have to find other tools, like Nadia mentioned, and others, in terms of domestic justice, in terms of promoting fighting against impunity through other means, in terms of supporting the ICC in the way we can by investigating, by providing evidence, etc., to try and slowly, incrementally move. And incremental progress is frustrating progress. That is definitely the case, but it's progress nonetheless. I'll stop here.
Thank you so much, Dao. And now we have the opportunity to have the Q&A session. And if you have a question, please raise your hand and introduce yourself and raise your hand. Who would like, yes, to start?
Yes, hello, my name is Igor Belyan. I'm a historian, journalist, analyst at Detector Media. So I do cover Russian propaganda, and I also was covering ICC and the arrest warrant on Putin 23 when I was at Army and Form. So my question is about these geopolitical tensions, and can we like compare these cases of Netanyahu and this war in Gaza and Russia-Ukraine war? I mean, in the context of like channeling of the problem, because we do understand that Russia is doing whatever they can in order to channel the attention from Ukraine to other conflicts, especially Gaza. And I do see that these arrest warrants were political due to channeling this problem. What do you think about this? Thank you.
Now we will have the opportunity to answer for this question. Who would like to start, dear panelists? Welcome.
It is a very provocative question, and I am not sure that I understand accurately. But I heard this expression that arrest warrant is political, so I totally disagree. Nothing happened in the ICC was political, including all publicly issued arrest warrants against Putin, against Lvova Belova, other force, and also arrest warrants in the case of Palestine. This is the court decision. Ukraine is a part of the Rome Statute. This is obligatory. We should execute this decision if we have this possibility. And of course, we have no grounds to contest the legal basis of issuance of these decisions, including because of a very high standard of proof used by Office of the Prosecutor as well as pretrial chamber in order to issue these arrest warrants. So just not to compare wars and sufferings of people, because it is also known very ethical. Crimes were committed in Ukraine, crimes were committed in Russia against Ukrainians, crimes were committed in Palestine, in Israel, and I hope that the ICC can solve all these cases properly and on the international law.
Yes, I can also respond. Well, first of all, it's very interesting that it's very good that there are journalists who cover Russian propaganda. And I was thinking, if NGOs had so much money and so many informaticians, IT specialists as Russia uses for its propaganda, there would be no criticism of the ICC and of universal jurisdiction, because yes, we are not an equal partner with this with Russian Federation because of financing, because of manpower also. So it would be great to have our own voice in media, so powerful as Russia has right now. And I was under an impression, I'm not sure if you have heard of it, there was an NGO covering Russian propaganda, antagonizing Polish and Ukrainian society in Poland, because it's huge. And the NGO was able to find influence, actual influence of Russian trolls on antagonization, on faking information or making real information very, very, very public, very multiplied. So that's something that we need also, and we have to stress the propaganda, stress that this is propaganda, this is fake. We have to pay so much attention to what the society sees in the media and listens to in the media. And I totally agree. on the previous issue that I don't see anything in the work of the ICC that would deserve to be called political. It's a very heavy accusation. We would need proof, evidence for that accusation. The ICC was constructed this way so that there were people from judges, prosecutors team, from all the parts of the world. And I always like to stress that the situation in Palestine was begun by Fatou Bensouda, who is from Gambia, and it's very hard to find any anti-Semitism in her society, in her environment. But it was certain that such accusations will be held. So if we have such accusations, we need evidence, and I don't see any evidence, and I see only suffering of victims who need help and who need justice. And as you said, that was very, very precise. Suffering of people cannot be compared. And the ICC was established precisely for that purpose, to provide justice for victims of any conflict.
Thank you. Dear Nadia, dear Dov, do you have a comment on this question?
Nadia, you can go first.
Okay. I was hoping I'd narrowly escape, but yeah, I have a couple of thoughts nevertheless. I agree with Kateryna, yeah, I agree that actually what cannot be disputed here is that the crimes have been committed in both situations that warrant the ICC investigation, right? That would be the sort of baseline. But I think the assessment of if we continue in the same vein as we began our discussion, to assess, you know, the degree of the political interference or sort of degree of political dimension in these processes, my feeling is that, and again, it's not substantiated, it's just based purely on my observations and internal analysis that I constantly conduct in my head, is that perhaps in order to achieve the results that the ICC set out to achieve in these investigations, perhaps the timing and other factors that should play the role in achieving those objectives should have been more carefully weighed, especially in the context of the, you know, very sort of unstable geopolitical environment, and also the sort of the, you know, continuing in the vein of the discussion in terms of the supporters and sort of the ICC supporters and ICC haters. I think we constantly should be aware and sort of weigh and balance out, you know, the sort of the power that those two categories play, because power shifts and sometimes supporters have it on their side, but sometimes haters have it more on their side. And if we, you know, and it's very well seen, I think, with, for example, the two consecutive states administrations, you know, Biden administration and Trump administration, and the risks that, you know, or the support that they carried throughout their presence or their rule. So what I'm trying to say is that there is a good time and good place for everything. And I think personal ambition in this very case took over of certain people. And I think that's what kind of undermined the process in relation to achieving the objectives in both investigations and destabilized essentially the entire court. I hope I made sense. Dov, over to you.
Okay, I'll share the thoughts of my co-panelist in saying that I reject generally the blanket accusation of political, you know, arrest warrants, etc., because, as was mentioned, you need proof of that. So I don't think that the prosecutor has, you know, politically influenced to issue an arrest warrant and not another. That being said, we can distinguish politics and policy. As I said before, deciding to issue an arrest warrant or opening investigation in a non-state party has policy impacts on the Office of the Prosecutor in terms of capacity to investigate, in terms of cooperation. And again, we cannot ignore that reality. There was a whole, for those of you who are not familiar, there was a whole discussion in the Afghanistan situation where one pretrial chamber at some point created this shock by saying that it would not be in the interest of justice to proceed with investigation in Afghanistan. And the judges came up with a number of reasons, like the fact that cooperation would be difficult, that it would cost a lot of money, but for a small number of victims, etc. And this decision was overturned on appeal, rightfully so. But what the pretrial chamber said was interesting from a policy perspective. It did raise a question of how much money should we spend on a situation where we will get zero cooperation, zero trials, zero reparations for victims? It's a real question, and it's not a nice question. It's not a question a lot of people want to hear. But from the Office of the Prosecutor's perspective, and we can come full circle to the very first point and rightfully put by Anna, sorry, I think it was Anna, on the Assembly of State Parties. At the end of the day, we work in a world of finite resources. And the Assembly of the States talk a big game, a big moral game, but they don't put their money where their mouth is. And so the prosecutor, every year at the Assembly of State Parties, I go there, and I hear states going to squeeze the budget. The budget of the ICC is quite small in comparison to what it's trying to achieve. And states, and when I say they're trying to squeeze a budget, we're talking about discussing whether you have an extra legal secretary or assistant or translator in one section of the court. This is how much detail it goes into when you're trying to cut the budget. So in that context, the prosecutor is constantly making choices, which might be perceived as political. And without going into the controversial situations like Palestine or Russia, again, when the first prosecutor, Luis Moreno Ocampo, is trying to get the ICC running, and he makes a deal with the Democratic Republic of Congo or Uganda, he's only prosecuting rebels. Because if he starts prosecuting the government, he will get no cases. Now, we can deplore that. We can criticize that. 20 years later, we can regret that only the Lord's Resistance Army was prosecuted in Uganda, despite massive evidence that the government has also committed crimes. We can regret that in the Democratic Republic of Congo, only low-level rebels from the east of the country were prosecuted, and no one from, the government or official forces. But if you were in Ocampo's shoes in 2004, it was either low-level rebels or nobody. And yeah, so you could say that's political in terms of policy. It's a difficult policy choice that had to be made by the Office of the Prosecutor.
Thank you so much. And now we have only 4 minutes for our closing remarks. And I invite all our distinguished panelists for 1 minute for your closing message for the role ICC and the future ICC. Kateryna, you with the first.
Maybe I will sum up with the future of us in the ICC in order to be quite optimistic as I was during the whole panel. And I'm quite optimistic also because of the decision of the European Court of Human Rights we had the last week, because I see some prospects and some arguments we can use in order to try to strengthen our arguments for the ICC, for example, in order to push the opening investigation as for discriminatory persecution as a crime against humanity. So we will do our best in order to continue cooperation with the ICC in the context of investigation, in the context of the issuance of new arrest warrants, but also in the context of cooperation with the ICC Trust Fund for Victims. We didn't mention it during our panel discussion, but it is also very, very important for survivors of the Russian crimes in Ukraine, and I'm sure that we will be able to use the ICC by effective manner.
Is it possible to show the slides right now? Yeah, thank you. So I have one comment. It's not that I want to show how busy I was preparing the PowerPoint presentation, but that's my favorite slide, and I've used it before. That's also our task. I think that there is a great task in our hands, because we have to lobby our governments, we have to inform the society, we have to use the media as wisely, better than the Russians do. And we have to show them how important it is for the states to cooperate, how important it is for us, for the society, for Ukrainians, Poles, Europeans, all the people in the world. And it is what Dov pointed out, that the ICC is quite busy with non-state parties. But I think from the beginning, the structure was used, the structure of the ICC provided for this possibility from the beginning. And right now, states not being parties to this order try to undermine it. So they try to destroy the world order that we created, because they think they are not part of the world order, that they are not part of the international community, that they are something better, that they should rule the international community. We cannot allow them to do it. And the non-state parties claim the ICC decisions have no meaning, including from a legal point of view. The ICC, that is Maria Zakharova in 2023. The ICC has failed to meet the expectations to become a truly independent, authoritative international tribunal. That's Sergei Lavrov, 2016. The ICC has engaged in illegitimate and baseless actions targeting America and our close ally, Israel. That's Trump 2024. So we can see the line of defying the order that has been created to protect the international community. So my wish is for the slide on the right-hand side. Stop. Thank you.
This is very frustrating. We do not see the slide online. Can we see the slide with the camera?
We will share a presentation with you, and it's about the prison, when the Putin will be the prison, and in the courtroom, and the all crimes that he committed against Ukraine and Ukraine people. Nadia, we invite you for your closing remarks.
Thank you. I will piggyback on what Anna's been just saying and continue the line of the list of the things that we still need to do. I'd also add to the list actually the ICC itself and us as civil society engaging with the ICC and pushing it to do better, because obviously it's not just the external threats that undermine the work of the ICC or the lack of cooperation, the sanctions and so on. I think it's also, internally the ICC needs to continue to evolve and must continue to mature. Because there are a lot of processes internally that still require improvement. That's one thing. And then also I wanted to address the comment that Dov made on the 27-year-old age of the ICC and the fact that it's not that young actually. When you put it that way, I think I agree. But then if you think about the ambition that it set out to become, then probably it's a lot bigger than what it can afford after 27 years. And I think it shouldn't be the achievement of that or realization of that ambition should not be just on the ICC. It should be on all of us. Those who believe in it, those who believe that it should exist, and those who believe that it should eventually become what it set out to become in its primary goal and mandate. Yeah, I'll stop here. Thanks.
Thank you, Dov. Floor is yours about the closing remarks.
Yes, I don't have much to add to what was said. I think that, there is, I don't want to give the impression that I was being pessimistic or negative. I was trying to set a scene in which we all operate to make improvement and improve the capacity. I was happy to hear Nadia say that the ICC must also look at itself from the inside and improve its practices. And I'm very well placed to agree with that. I've seen it from the inside for many years now, and there is definitely room for improvement. So, we all do our job on a daily basis. One thing which came out in the discussion, and I'd like to finish on, is the ICC is just one element of a broader justice project. I don't know which other word to use. And, there was in your list a very ambitious list of questions, Nataliya, universal jurisdiction, etc. We didn't have time to go into that, but I think it's really important to say that, is that one thing that deserves ICC is that there's a lot of hope put in it, and I think it's justified hope within the context of what it can do. But even a perfectly functioning ICC would never achieve all the ambitions of post-conflict justice, reconciliation, truce, etc. that some people put in it, and it wasn't designed for that. So we have to make the ICC better, but never forget it's part of a broader justice project in a broad sense, which includes universal jurisdiction, NGOs, capacity building, which everything is being done, and I hope to contribute, in my level in Ukraine, in terms of training judges and prosecutors and having domestic trials that function and having the European Court of Human Rights do its thing and having other states do their thing and different NGOs and organizations contributing to that broader justice project. And the ICC is an important, but just one aspect of that. And I'll stop here as well.
Thank you so much. And now we finish our panel because we respect your right to lunch, and that's why we finalize our discussion. And thank you, our very distinguished and panelists, for this very interesting discussion.